Well, welcome. We've got 6 of our 10 registrants who have come on time, so good job being on time. And all our folks in the class that are on time today too, very good. So Sam, it's 9 o'clock, so if you're ready to go, please introduce yourself and take it away.
Yeah, let's hit the ground running. Good morning, guys. Sam Colburn, one of the attorneys here at Woods, Weidmiller, Machete, and Rudnick. Just a little bit about me before we get started. I am born and raised here in Naples, lived here most of my life, did move up to the Northeast Boston for about 10 years after all those winters, decided to move back home 2 or 3 years ago and had the Ys up there. So born and raised here, very familiar with the area, real estate market. I've seen kind of all the ebbs and flows from past years, so definitely have some local knowledge to bring here. So today we're talking about the FAR listing agreement, all right? So we're going to keep NABOR out of our heads. We'll bring up some of the distinctions about it today, but we're really talking about the listing agreement, not the contract, anything like that, and really showing how you guys can get that commission the right way, all right? Leading up to all of that, and we'll kind of hit the ground running from there. This is kind of the presentation of how I'm going to kind of ring through everything. Kind of want to have a general discussion of listing agreements in general, kind of make sure everyone's on the same page with the various ones. We're going to be kind of mainly operating under a transaction brokerage agreement today, talking about some of those distinctions here. We'll go through what the requirements are for a residential listing agreement. Under Florida, there's a few requirements that it has to meet, and we'll kind of run through those. And then we'll kind of get into the meat and potatoes of the seminar, is getting through kind of the form listing agreement. We'll go through it line by line, item by item, and kind of run through there. And then also one thing that I'm going to be highlighting throughout the presentation, and you'll see it either highlighted later on in the presentation in the different clauses or via a red mark saying CCP, is that there's new amendments that came into effect just May 1st that a lot of folks aren't aware of. So we're going to run through those, make sure everyone's on the same page. I will say that I know everyone's going to be either getting a copy of this PowerPoint or is able to download the PowerPoint. There's going to be a ton of information in here. I'm probably not going to read every line by line through here, but just want to make sure everyone's on the same page. I know this is also being recorded for everyone if they want to go back and look at this in the future and kind of match up with the listing agreement and the PowerPoint. And, you know, by all means, if you have any questions after the presentation or even after a couple of days go by and you want to pick my brain or anything like that, my contact information is listed on the very first page of the PowerPoint. So general information here that we're talking about. So for purposes of today, we're just speaking about residential listing agreements, all right? 3 main listing agreements that we're working with. All right, the first is the exclusive brokerage listing agreement, which is the listing agreement that's granted by the seller to the listing broker. That authorizes the broker to sell the property and offer cooperation to other agents. All right, this is kind of the one that we're going to be working with today. Exclusive right of sale of the listing agreement, non-listing agreement granted by the seller to the listing broker, and this is the sole right to sell the property. Agreement requires co-op for the buyer's agents and transaction brokers. And then the third one, which is the single agent listing agreement, okay? As we run through this, like I said, Florida law presumes a transaction broker one. If we want to get into a single agent form, we're gonna have to use a different form, which we can cover under a separate seminar, you know, at a later date. So same with your contracts when you actually get a purchase and sale contract. These listing agreements are, yes.
Sorry to interrupt. Could you mind doing, if you do from beginning or from current slide, the play from the current slide at the top of your screen, I think it would make it bigger to see. There we go. That's perfect.
All right. Yeah, I was trying to do a split screen because I had some things up here, but no.
If you want to do it the other way, that's fine. It just
no. I just want to make sure I can go back and forth because I'm going to go back and forth a lot. But that works well. Is that better for everyone?
It's a little bigger for us to see it.
Yeah, perfect.
Okay.
So from the standpoint of working with your purchase and sale contracts, it's only, good as the information that you're plugging in, right? Garbage in, garbage out, good information in, good information out. So you want to make sure that these listing agreements are conveying what your understanding is with the seller at the time of entering into it. If you're making any modifications or amendments to the form, you want to make sure to speak to me or one of the other attorneys here at the firm before we start tinkering around with things. Make sure that it's all right, that we're not entering any, illegal provisions that would invalidate the contract or the listing agreement or anything like that. All right. Like I said, the listing agreement is an agreement for services. Doesn't need to be in writing to be enforceable, naturally. So, I mean, when we have this listing agreement, and on the next slide, you'll see what Florida statute actually needs it to be in writing. But as long as you have an understanding between the parties, you actually don't need it to be in writing. Now, obviously, you want it to be, but we have seen in Florida, like a contract, oral contracts are perfectly valid in the state of Florida, all right? Except for a few exceptions there. But here we have what the requirements are for a written listing agreement pursuant to Florida statute. 5 things that need to be in there. So you're going to have a definitive expiration date. Make sure that you have the full property description. Going to want the total purchase price and any of the terms that come along with that. What the compensation for your broker is, and then the seller and broker signature on the final page. A lot of people will cross this as we get to the end of the presentation, but it's going to be the broker that's signing off on the listing agreement, okay? And that's kind of one of the things. And one of the things that actually can invalidate it, which is why I said if you are making any amendments to additional terms or adding anything on there, is that there can't be a provision that requires the owner or seller to notify the broker of any intent to cancel it after the expiration date. So we'll see that there's a standpoint that you can put in essentially after the termination, say in 30, 60 days or whatever, that, the broker is still, obligated to get that fee, get that commission, but we can't specifically put that provision in here, all right? Kind of general terms, make sure everyone's on the same page. It may seem like common sense, but you would be surprised at how often we come across not only listing agreements, but also contracts that do not, fill in all the blanks. And then we're kind of left, was this ever disclosed to a seller on a contract more? Was this ever actually disclosed to a buyer? And then we can get into all kinds of issues. So you run through line by line. The good thing about the listing agreement and your contracts is that if you actually look on the left-hand side that has all the line numbers, there's a little asterisk there that will kind of tell you what needs to be checked in. So just make sure you're doing a second look at all of that. If a specific provision doesn't apply, cross it out and make sure both parties initial. Same thing with any of your form contracts. And like I said at the beginning, if you do need an amendment or an addendum to the listing agreement, make sure you contact us to make sure that everything, all your ducks are in order there. We're working purely with residential real property today, all right? So get any of the commercial transactions, sale of businesses, purchase sales agreements like that, tax exchange, anything, get all those out of your head for today. We're purely working with residential real property. And this is how Florida statutes define what residential sale is, all right? It's a sale of improved residential property of 4 units or fewer, the sale of unimproved residential property intended for the use of 4 units or fewer, or the sale of agricultural property of 10 acres or fewer. So a lot of the times it's going to be pretty evident if you're working with residential. I mean, one thing that I always like to say is you may want to just ensure that you're checking either on the property appraiser's website when you get the legal description from the prior deed that it's zoned for residential, all those things like that. More so for vacant lots that you're working with if you're trying to represent someone like that. But keep in mind that we're purely dealing with residential today. Commercial listing agreements are going to have some other distinctions that we can bring up at a later time. So let's get into kind of the meat and potatoes of the agreement, all right? And this is the first couple lines of the listing form. And like I said, some of this may seem fairly self-explanatory, but you would be surprised at how often in contracts that even this first part isn't filled out correctly, all right? So from the seller standpoint, we want to make sure that this is completed correctly and completely, all right? And what do I mean by that? We want to make sure that the seller has the authority to actually convey this property, all right, in the first place. Example, I'm working on a file right now where we're actually supposed to close in a couple weeks. Seller is essentially 3 tenants in common where someone owns 50% of the property, another one owns 25%, another one owns 25%. One person didn't realize that the listing agreement or listing agent actually didn't realize that one of the people died a couple of years back and had someone sign the contract that hasn't been appointed PR for the estate. Supposedly she thought that she had done a quick claim from her individual self to her trust before she passed. That never got recorded. Arguably the contract is null and void because no one had authority to convey that property on behalf of her. So make sure before you do all this work, this is kind of the first step. You want to make sure that the person that you're entering into this listing form and eventually going to be selling the property for has the authority to sell, all right? If it's a corporate entity, an LLC, corporation, anything like that, make sure you go to SunBiz, which is the Division of Corporations website that you can find, and just make sure that the correct name is there. Make sure that it's a member or manager that's authorized to sign on behalf of that entity that's signing the listing agreement or said contract. If it's a trust that's the seller, a common misconception is that the trust is the owner of the property. That's incorrect. The seller is the trustee of the trust. All right, a trust isn't an entity. It can't be an owner. The seller is the trustee. So we want to make sure that it's Sam Colburn as trustee of the Sam Colburn Trust, so on and so forth, signing here. And if someone is signing on behalf of a POA, make sure that you get a copy of that POA. Make sure that you run it by us to make sure that it complies with Florida law. And also you'll need to get the original of the POA because that would need to be recorded at closing when that eventually happens. New policies as of May 1st. There's a lot of information here, and this is going to be one of those slides that I just kind of want to briefly go through because as I go through on the next couple pages, I'll give you a kind of short explanation of what this really means. But at the very top, the National Association of Realtors came out on May 1st, a new policy essentially stating amending any pocket listings that are out there. So there's the listing brokers have to comply with a bunch of different scenarios now. Mainly within 1 business day of it being marketed to the public, a listing broker has to submit the listing to the MLS for cooperation with other MLS participants. We'll get into what actually marketing means. Are there exempt listings? You'll see section 1.3 here gives a little bit of exempt listings. How does these exclusive listings come into play? Run through that, and you'll see at the top here I highlighted it in red, and also as we go through you'll see pinpoints that I broke down that kind of breaks down what is new or what was old from the old listing agreement and what is new now. So you'll see those distinctions as we begin to go through everything, but a short explanation of what happened is right here, all right? Within 1 business day of marketing a property to the public, the broker must submit the listing to the MLS. The property has to be the subject of an exclusive written listing agreement signed by the sellers. Again, the verbal open listings are not permitted in the MLS, so they're not subject to this new Clear Cooperation 8.0. And we have a list of what public marketing actually means here. Flyers displayed in windows, yard signs, any kind of digital marketing, multi-brokerage listing sharing networks. All of this triggers all these new requirements that listing brokers need to take into account. any marketing to the public outside your brokerage, all right? Any shape, fashion, or form, you're going to have to be aware of these distinctions and what your obligations are. Essentially, for NAR's rationale of coming up with this is to do away with pocket listings. Now, if someone's not familiar with what pocket listings are, they essentially around to maintain exclusivity for a seller to make sure that maybe it's not actually being, propped up to the all buyers on the market. And NAR came out and essentially said that this is reducing buyers' choices on the market, skews any of the market data, and it really isn't in the seller's best interest. So we'll see as we go through these new requirements that a seller can actually still choose not to market it to the public, but they have to affirmatively check off a box. They have to initial it. We'll see that as we go through, and I'll make sure to call it to your attention because that's one of the biggest changes that we're going to see in the listing agreement from years past. And a common question that we get is, do I get a pass if my seller tells me it's okay to advertise their property before submitting the listing to the MLS? And the answer is no, you have to submit it 1 business day after you publicly market it, after you publicly market the property. One of the exempt listings that kind of talked about earlier are these office exempt listings. So if you're exempt from this Clear Cooperation 8.0, if you're listing it within a listing brokerage, just to clarify, your brokerage is affiliated with a franchise, you can still share your listing with those brokers and any agents that are independently owned and not within your quote unquote extended family, all right? For those that, a common question that we're getting is, what are the ramifications if we're not meeting these? And to be honest, we just don't know that yet. It appears that NAR is reaching out to the local MLSs that have it being, fines on a local level. For those that, essentially cost of doing business, the cap on that is $15,000. So we don't even know what the local penalties are yet. But that's a cap there. So some folks are just saying, we'll just eat that 15 grand as a cost of doing business from that. It's kind of depends on your business model. And also this frankly isn't going to apply to every listing agent either. So it's kind of on a case-by-case scenario. It's a lot of information in here. I made sure to pinpoint it all on an earlier slide to go back and review it later, but I'll make sure to call out the major things that I want to bring up as we start getting into the listing form now. All right. So this is the first couple lines of your listing form, the authority to sell the property. Line 6, you'll see that it has that asterisk there that I was talking about earlier, calling out that you need to make sure that these are filled in. Or you want to insert the dates to establish your term of listing. You want to make sure that it begins when you want, and you want to make sure that it terminates when you want. Right, lines 8 grants an automatic extension through the closing date, if you have that. Right. Lines 8 and 9, guaranteeing to the seller that there is no guarantee. Just because you're entering into this listing agreement doesn't mean that I am guaranteeing the sale of your property. In fact, to the opposite, you're not guaranteeing anything that you're working, except for, you're going to be the exclusive broker working on this property. Lines 9 to 10 have some boilerplate equal opportunity statements that have to be in there pursuant to federal law. And again, line 11, seller certifies and represents that it is legally entitled to convey the property and all improvements. Again, that goes back to my earlier point. Let's make sure that we're sure here, okay? Don't rely on the seller's word. Make sure you're doing your due diligence to make sure that the seller actually has the authority to convey the property because I've seen it too many times, unfortunately, that we get all the way, the property is listed, find a ready, willing, able buyer comes in, puts an offer down, we get to title, and we realize this person doesn't even have the authority to convey the property. And now you've just wasted X amount of your time doing all of that. So that's no fun for something that Really only takes a couple of minutes of your time to make sure. Next couple lines have the description of the property. All right, we want to make sure that the line 15 and 16 have the correct legal description. That's why we want to make sure we go to the property appraiser's site, pull the current deed, make sure that the legal matches up. We don't want to get into a situation that there's some kind of legal description that was in here. We have a dispute over what property we're actually even selling. Like I said, some of these things seem like common sense, but I can tell you from experience that we have seen this, at least on a couple of occasions where this property isn't even the property that's being sold, and we're getting into a whole kind of mess here. Again, you'll see on the left-hand side, everything needs to be signed here, filled out. Make sure that if no lines are filled out, you're putting a cross through, you're checking all the boxes, any kind of things that you're crossing out, make sure that the parties are initialing so everyone's on the same page. Lines 17, 18, and 19, talking about the personal property here. Again, obviously, when you get to the your FAR/BAR contract or your neighbor contract, you're going to have to include if there's any exclusions or inclusions for the property, for personal property here. Again, we always suggest that there's an inventory of personal property that's attached to the eventual contract. You can also attach it here with just the attachment of what personal property is actually going to be conveyed, or if the seller wants to exclude some personal property, make sure that those are check marked here and you're attaching that inventory. And then line 20, the property is occupied by a tenant. Make sure you get any of those copies of those leases now. As you know, on the contract, you're going to have to disclose that, depending on what contract, typically within 5 days of entering into that contract. Just going to make your life easier to get all this paperwork now, because you don't want to be stressing after you get someone under contract and you're like, oh, did I ever get those leases? Just make sure you kind of run through this now. This is really a form that you're using to really protect yourself, right? So make sure that you're taking your time to go through it, make sure all the boxes are checked, anything's checked, and make sure you're getting copies of any necessary paperwork there. Price and terms. A few things here. Let's make sure everyone's on the same page. Want to make sure that the customer is comfortable with the listing price, have the purchase price there. Make sure that you're getting comps and everything of what like the purchase price they're looking for. Is that in a reasonable listing? Everything like that. And you want to also make sure that your seller is comfortable with the terminology here. Some people may not even know what a purchase money mortgage is, right? So that's typically when a buyer can't qualify for conventional financing. The seller is going to end up seller financing some of this transaction. If the seller is willing to do that, obviously you don't have a buyer at this point, but if the seller is willing to do that, make sure that you have terms here that you're willing to work with, all right? And also, if the buyer is going to be assuming a mortgage, put down if there's a mortgage on the property, what's the payoff there? What's the eventual payoff? How much are we actually getting to work with? Line 3C section, or line 3738, section 3C rather, has some seller expenses here. So make sure you put the maximum percentage if the seller is going to be paying any closing costs. Common question we get are what are closing costs? A lot of folks think that it's just this whole kit and caboodle of everything's road, commissions, attorney's fees. That's not true, right? We know commissions are separate, attorney's fees are separate. But title insurance, doc stamps, recording fees, all these things, lender's fees, all these things that a seller is going to have to do to effectuate the transaction. All these things, make sure that are in there so that the seller knows kind of exactly what they're going to be doing. And obviously we do it all the time where we can help prep a very preliminary closing statement for parties that give a seller or a buyer, for that matter, kind of expected closing costs, right? There's going to be common costs that happen on every transaction: title insurance, doc stamps for sellers, recording fees for the deed or the mortgage. All these things are kind of, on every transaction. So if your seller has any questions on what their common fees are, Title insurance has a promulgated rate under Florida law. That's easy enough to calculate. Doc stamps is 70 cents on every $100 of the sales price. It's easy enough to calculate that. And then the recording fees are typically $10.50 a page for that. So, I mean, just reach out to our office and we'd be happy to assist on getting you some numbers on that. So here's the first distinction from the old listing agreement to the new listing agreement. And we'll see that some of these may seem trivial in nature, but I assure you there's a reason in it for everyone. So lines 39 to 40, what are your obligations as a broker? The broker agrees to make a diligent and continued efforts to sell the property in accordance with this agreement until a sales contract is pending on the property. So both the broker and seller now have to agree that marketing and sales efforts will be in accordance with this agreement, the new requirements, the clear cooperation policy that I went through before. So the broker does have some more requirements and obligations to meet than they did prior to May 1st. And that has to do with making sure that the property is listed on the MLS if it's publicly marketed within 1 day. Make sure that we have these services to perform by the seller's agent. And this is the time that you really need to set the expectations with your seller about what your expectations are, what they can be expecting from this. Because otherwise, if the owner's expectations aren't met, typically they can have good cause to terminate that agency between you and the seller. Make sure that you're analyzing the property, marketing the property to the best of your knowledge, and you're keeping all kind of documents and evidence by detailed records. Keep any of the solicitations that you have, any of the contacts that you made with regards to the property, any money that you spent, any marketing, buyers contacted, all this stuff so that you can actually show if the seller comes back to you and says, hey, why don't I have a ready, willing, and able buyer yet? Say, hey, I've contacted 20 buyers in the last, it's just not working out right now, so that they can't terminate the agreement if they don't have good cause there. And so that kind of goes through, and we'll see later on in the form agreement that lists out specifically what the seller's obligations are. But even if it has the seller's obligations, I'll call the one point something that's specifically going to be the broker's responsibility as well. Next, on the multiple listing service, we have a couple of different sections here. And this is probably the biggest change from years past that I want to call to everyone's attention. It's kind of something that I've been harping on earlier today. The broker is obligated to enter the property into the MLS within 1 business day of marketing that property to the public. What is marketing? And we'll see this on the next page. Both broker and seller have to agree that the property will be entered into the MLS unless the property is not to be marketed in any way, shape, or form to the general public. As I said on this next page, or one page further actually, the seller is actually going to have the obligation to say, I do not want to publicly market this, and the seller is actually going to opt out, check a box, and initial underneath it. I do want to say that this is 6A here, market the public property to the public marketing, and this has everything that I went through earlier. This is going to be your default option. Okay, so if box B on the next page when I show you isn't checked or initialed, the default is going to be this 6A. So you're going to have to remember that you have to get this uploaded within 1 day of it being listed to the property or publicly marketed. So this section still construes some of the obligations that the broker has, whether or not the property will be marketed publicly or privately. And if it is, like I said, it has to be put up on the MLS within 1 day of the first public marketing effort.
And Sam, I wrote something online to the folks there, but also for the folks in the room here that, if you don't market it publicly, it's just based on the contract and the MLS rules on how quickly to get into the MLS. But public marketing is anything like a for sale sign, a post on Facebook, or anything like that. So if you do that, then you have to get it in the MLS. But otherwise, you can actually market it on the mypremierplus.com website. So intranet only. So you can put a message on the message board to almost 1,400 agents as far in advance as you want, because that's not considered public marketing. Or you can talk to someone one-on-one. But if, when in doubt, just don't try to market it too much. Just get it in the MLS so all the other realtors can do it. But, that's where we're here for too, as the Mentor Edge program. We want you to have this overview, but then when it comes time for your listing, we want to go over these details again and walk you through some of this too. But it is important because they are catching people right now and looking out for those violations.
Yeah, exactly. And that's a great point, because I mean, in section 1.3, which I talked about earlier, that's actually one of the exempt, right? So you can talk within, your nature of your company, anything like that. But after you start going quote unquote public, based upon what is listed here in lines 50 through 53 of what public marketing includes, that's going to trigger this obligation. Any other questions on that while we had a little stop? Is there any kind of...
For what reason seller might not want to market it publicly? Is there a reason for this?
Yeah, have you ever heard of any good reasons for a seller not wanting to market it publicly?
A lot of folks, and I'll go to this next page here, of why a seller doesn't want to. Typically, the old rationale behind pocket listings is that they want to retain exclusivity over it. Maybe they're a famous person. Maybe they don't want the attention of having their property listed out on the open market. Typically, we see it on folks who either just don't want to, they just want to remain private, have a smaller network of folks to list it. There's different rationales or, psyches behind it. But the typical aspect that we see is if someone, wants to try to retain exclusivity over their listing for whatever reason, and they don't want to really, have a for sale sign out their property. They don't want their property on the web anywhere, or Facebook or anything like that. So that's why this 6B here is not the default, right? Because the majority of people will not select this, but it is an opt-out provision here that is all new. You'll see that I highlighted this entire provision, and you want to make sure that this is definitely one of the new provisions of section 6 of this listing agreement that you want to make sure is handled accordingly. So you'll see that the seller has to check off the box that the seller does not authorize the property to be marketed on the MLS. Seller understands that there won't be any signs placed on the property, that the broker may market only to other agents in the broker's local office. So that goes to Sarah's point earlier about that's still obviously permitted for that. And the seller has to initial here as well, okay? Going down on section 6 are a couple of the other informations. All of this has been in the listing agreement as well. We have a couple of check boxes here that we're going to be obtaining the information related to the present mortgages on the property. That goes back to getting kind of that assumption of mortgage number on one of the earlier slides. We want to, we're going to be providing comparative market analysis to potential buyers. This is the section lines 68 through 71 has the lockbox information, release of liability. We want to make sure that these are checked off. Line 72 has withholding offers. So this allows the broker to withhold offers once a seller accepts a contract on the property. Reminder for people who may be unaware is that you have an obligation to present all offers, counter offers to the seller, unless you're directed otherwise in writing. This is where that box comes into play, is that Florida law actually mandates a licensee, who's you, to give your seller any of the offers, counter offers in a timely manner, unless they have agreed otherwise. So one of the practice tips that I wanted to call out is that I always would recommend even putting this as an additional term at the end, just calling it out to everyone's attention. That's perfectly agreed upon because this is a statutory provision that isn't waivable. And then 6F, you're a transaction broker on this one, right? Reviewing with the client the concerns of posting, market value reviews, working with your seller in a way that works like that. And then we have lines 74 through 83, the virtual office websites. The seller isn't authorizing an automated estimate of the market value of the listing or does not authorize third parties to write comments. Again, you'll see on the left-hand side that all these need to be checked off or not checked off based upon your understanding with your particular seller on this property. Section 7, seller obligations. So this goes to what I wanted to say before, and I apologize. Some of the numbers at the bottom, 7C and 7D, are actually one bit below her, but I'll run through, make sure everything kind of makes sense. We want to make sure that the seller, knows what they're agreeing to. The seller is going to have obligations under Florida that may not be the same at the same state where they're from. I'll go through 7G, which is the Johnson v. Davis rule, one of the biggest landmark cases here in Florida that every seller, buyer, agent, attorney needs to be aware of, and go through that. So the seller has to understand that these provisions are not waivable. Any of these provisions that came in Section 6, you can't waive them. So there will be penalties assessed for these violations. Like I said, it's kind of, everyone's harping down on it. It's on a local level right now, but it's hard to say exactly what those are. But you essentially just make sure that you're calling to their attention what the seller's obligations are here. Make sure that they're aware of anything here. Section 7E, you have the indemnity. The seller is going to indemnify you and hold you harmless for losses, damages, costs, expenses, any of that nature due to the use of the lockbox, the existence of undisclosed material facts about the property. I'll get to that one in 1 second. And any kind of court of arbitration decision that comes down with it. The seller is going to have an obligation to comply with FIRPTA, the Foreign Investment Real Property Tax Act. So essentially, if someone is a foreign seller, they're going to be responsible for complying with the Internal Revenue Code for there. Obviously, our office can be able to help with that, and their individual CPA or accountant will take the lead on that. But the biggest provision I want to call here, because this leads into contracts, everything that really agents really need to be aware of, is 7G. All right, and this is what we call the Johnson v. Davis rule. In consideration of brokers' obligations, sellers agree to make all legally required disclosures, including all facts that materially affect the property's value and are not readily observable or known by the buyer. Seller certifies or represents the seller knows of no such material facts, local government building codes, observable defects, all of this that materially affects the property. So this is specific to residential, okay? We're only dealing with residential, but courts are consistent throughout the state of Florida that a licensee, i.e. an agent, broker, is liable for any violations of this to the extent that they have actual knowledge of any defect or violation. Let me give you a big example, are special assessments, right? If you come into knowledge by the seller when you're listing the agreement, or if you're prior under contract or under contract, and you're aware that, that association is coming down the pipeline with a rather large, hefty special assessment, and you don't disclose that, you're going to be on the hook just as much as the seller is. So this is very important. Obviously special assessment has a material, effect on the value of the property, because we've seen condominiums selling for $200,000 that come down with a special assessment for 50 grand on those. So special assessments are definitely something that you want to make sure that aren't out there. Obviously, it's a tough burden to prove on the buyer's end, just from a legal standpoint, because you have to show that the seller was aware of this material defect and purposely did not disclose it, right? I mean, our litigators in our house deal with this issue a lot. So it happens more frequent than you would think. A buyer gets into a house and they feel like they should have known something that the seller didn't disclose. It's a pretty high burden to prove, but just make sure that you keep those in mind. I'd like to always call that to attention because this is something that we don't want to see come back after, the property sold 6 months down the road and we were aware that the special assessment was coming, seller didn't disclose it, something like that. You just don't want to make sure that you're in that kind of position. And then obviously the seller's obligations, they'll consult the appropriate legal, tax, property conditions, all these things for specialized advice. Consult a tax professional for FERPTA, consult us to handling all their legal documents and declaring title and all those things. So let's get into compensation, all right? How is the broker actually getting compensated for everything? So this commission plus flat fee allows the broker to obtain that percent commission plus that flat fee, all right? That marketing fee, that coordinating fee, all those fees that you're doing to make sure that this property eventually gets sold. You'll see on these asterisks here, again, you want to make sure that everything is completed. So the seller is going to pay you, 6% or 3% or whatever those numbers are, or a flat fee based upon everyone. And think about what your out-of-pocket, costs are. The RESPA, the Real Estate Settlement Protection Act, allows the broker to charge a combination of both. So separate fee has to be disclosed. If you're just charging an additional $195 fee on top of that, all this has to be disclosed to the seller. Big things, big principles are largely about disclosure, not telling anyone that something that they don't know. Just make sure that everything is disclosed. And that's why I like to say, make sure that all the boxes are checked off. You got everyone, if there's a change, make sure that the seller is initialing off on that change. You're keeping documents of everything to protect yourself, and everything should go fine. One thing that is want to make sure is on the same page is that the broker can't charge a transaction fee if the listing broker doesn't perform additional services to justify that fee. So section B here allows the broker to obtain that fee if the seller enters into a lease agreement to enter the property, but that fee isn't due if the seller doesn't enter into that exclusive right to lease. Section 8D has kind of the when your fee is due, right? So ready, willing, able buyer, all this is when your commission is due. So number one, the transfer and interest in the property with the assistance of obviously you, finding a ready, willing, and able buyer, coming to all these terms, making sure that everything is met pursuant to this listing agreement. The seller refuses to sign an offer at the price and terms stated in this agreement. Okay, so the terms, that's why I want to make sure that on the very first page of the agreement, we're having in the terms that we want the seller to abide by. Because if you find a buyer that comes by and offers you these terms and the seller turns it down, they're still obligated to pay you your commission, okay, on here based on this. The seller defaults on an executed purchase and sale agreement, and we'll see this on one of the following pages about retaining deposits as consideration for broker services. Seller agrees with the buyer to cancel purchase sales agreement when buyer had no contractual right to cancel. Again, if in the event of a buyer default, we'll see how a broker can actually have a claim to 50% of the deposit or more if it's filled in. And then also in line 122, we had that protection period. So remember on the very first page of the listing agreement, we went through and put in a termination date. Here we can actually put in that time period after that actually protects you. That's actually called a protection period in here that, whereby 90 days after the termination period, if the seller transfers or contracts that property, you're still obligated to retain that commission there, okay? So make sure you fill in the blank there because there's no auto default, sometimes if left blank, it will be 30 days. There's nothing like that here. So make sure that you fill in line 122 accordingly. And here's that next retained deposits that I just spoke upon. All right. So in consideration for broker services, the broker is entitled to receive X% of all deposits that the seller retains as liquidated damages for a buyer's default in a transaction. Okay. That can't exceed the fee that we list here in line 109. All right. But we'll still, provide this. All right. So remember that your FAR purchase and sales contract has this portion of it listed in there. So this is where it's a little different than your NABOR contract. And it specifically says the portion of the deposit, if any, paid to the listing broker, presumably pursuant to section E above, upon default of the buyer shall be split equally between the listing broker and co-op broker, providing, however, the cooperating broker's share shall not be greater than the commission amount listing broker had agreed. All right, a lot of kind of little mumbo jumbo. Essentially, broker, you're entitled to receive 50% of that buyer's deposit if the buyer defaults on the transaction, right? So the seller gets 50% back, you get 50%. Obviously, you can fill in the blank there. If it's left blank, note how I said on the last page here at line 122 that this will default to 0 if you don't fill anything in. Line 127 defaults to 50% if it's left blank. All right, so you don't even have to fill in something there. It will auto default there, obviously negotiable with your seller at that point. Section 9, cooperation with and compensation to other brokers. This is the notice that the broker may offer different amounts of comp to buyer's agents, transaction brokers, with no broker's relationship actually to the buyer. And typically this is the same across the board, all across your different agreements here. So the broker's offers policy is to cooperate with all other brokers, except when not in the seller's best interest. And here you put the percentage of the purchase price. Again, more lines to check off. Make sure that your purchase price to the single agent for the buyer is disclosed, what all these amounts are. Or, line 136, if this isn't even going to be applicable to your transaction, you can make sure to just check off, that none of the above box on line 136. Next, we're going to talk about how the brokerage transaction broker relationship actually works. So I talked to you about the beginning that if you're desiring a single agent relationship listing agreement, you're going to need another form. We're working with transaction brokers, right? Transaction broker provides a limited form of representation to a buyer, a seller, or both in a real estate transaction, but doesn't have any fiduciary capacity as a single agent. So here, lines 137 through line 141, broker will act as a transaction broker. It says it pretty clear and stated. Broker will deal honestly and fairly, will account for all funds, will use skill, care, and diligence in the transaction, will disclose all known facts that materially affect the value of the residential property, which are not readily observable to the buyer, right? Ding, ding, ding. That brings back Johnson v. Davis, which I just talked about. Will present all offers and counteroffers in a timely manner unless directed otherwise in writing, and will have limited confidentiality with seller unless waived in writing. Okay, so here we have I listed out a definition of what a transaction broker is. I spoke in the beginning that Florida law actually presumes a transaction brokerage relationship. So if you need that single agent relationship, make sure you're using a separate form here. In that single agent, I listed here, defined by Florida statute again. And it's someone who is representing either the buyer or the seller of real estate, but not both in the transaction. Okay, that way the seller or the buyer, they know that you are only representing that customer's interest. You don't have any other. You're not the listing and selling agent on the property. You're just handling one. Section 11, we're getting into, conditional termination. So here, what kind of agreement are you going to have about if the listing agreement is terminated with the seller? Okay, so this says, at the seller's request, the broker may agree to conditionally terminate this agreement. The broker agrees to conditionally terminate. The seller must sign a withdrawal agreement, reimburse the broker for all your direct expenses, and pay a specific cancellation fee. All these, if if you're putting in a conditional termination here, make sure that you have a amount here that actually would, appropriately compensate you for additionally doing this. This isn't, a requirement to put in an additional cancellation fee, although I would always. Line 144, you see that asterisk again, that makes sure that we want to fill in the blank there. So like I said, termination fee, this reimburses you for any of your direct expenses, your protection period, any kind of things like that. So make sure that if the broker, if you do void that conditional termination, the seller will pay that fee. Way back in section 8A, right, where we had that termination fee there. So that's how that will kick in. We start getting kind of into a little bit more of the miscellaneous provisions with the listing agreement. Here we have what happens if there's a dispute that comes up between yourself and the seller. So this kind of governs out, stating that everything will be construed before the law, required to, put everything to mediation. So for folks who may not be aware, mediation is essentially an informal settlement dispute to try to, settle anything before stuff actually gets brought before court. Parties will agree to split all the costs. Any of the litigation that arises out of your mediation, the prevailing party is entitled to attorney's fees. A lot of things, that's one thing that obviously we're dealing with the mediation section here, but on my end, when I get a seller or a buyer who, wants to terminate a contract or think that they have a claim to the deposit under the contract, have to really be frank with them on my end, on the legal end, because a lot of folks don't realize that they're going to be on the hook for the other side's attorney's fees if they end up bringing a suit and lose. Okay, so I mean, some folks have a fantastic case and they want to do it, by all means. But a lot of folks, litigation is costly, takes a ton of time, everyone's time. Someone has a $10,000 deposit, wants to, bring a lawsuit against, the buyer for whatever reason, or vice versa. And long story short, we're a year in the litigation, the parties have 40 grand in fees, at least. So that made that 10 grand deposit seem trivial after everything like that. So, and then 154, these have to be initialed again by everyone. Parties can opt into arbitration other than filing a formal lawsuit with the court. So dispute resolution in front of an impartial arbitrator. Arbitrator usually decides a matter and can issue a award. Think of an arbitrator as a judge, but not really. Still have a hire a lawyer. Still going to be costly, no matter how way you do it. But like I said, it still has this attorney's fees provision. Each side will pay their side there when you get to arbitration. So the party split cost is only on the mediation end. Couple miscellaneous terms here. So we have the, this agreement is binding on the sellers and brokers, heirs, assessors, assigned. So if the seller, assigns this a listing contract after they get under contract, and the seller, whoever does that, not that they necessarily would, but this is going to be protecting you through that termination date. So death of the party, if someone, if a seller unfortunately passes away when you have this listing agreement, and then the estate needs to come in to, handle any of the sale, this agreement is still valid. So the contract of terms express the entire agreement between the parties. This is one thing that we call a merger clause, essentially states that no outside representations are to be essentially relied upon. This is the party's full agreement. This is going to be the contract that governs in case there is a dispute, what the agreement or who's going to be liable for any damages, who was in the right, who was in the wrong, anything like that. And on one of the last pages, we have the additional terms section. So we've seen some, agents put in some stuff here that wasn't necessarily approved by the broker. Some things that necessarily may not have made sense at the time, but had some specific things that they thought they wanted to add in. Just make sure that you contact us before you start adding in. Make sure that this is the appropriate time to add that in. Maybe it's not actually until you get to the you get to the end of the contract and you start negotiating the terms of the contract, everything like that. But make sure you're just listing out all these additional terms, getting kind of form feedback from everything like that, and can kind of go from there. And one of the last pages of the listing agreement has all the signatures, right? One thing I like to call to everyone's attention is that the agent isn't signing off on this. You're not signing off on this. The broker signs this listing agreement. Okay, so you want to make sure that that happens. The seller is signing. Again, make sure that the appropriate party is signing on the seller. Don't want to get into one of those situations that I'm having to deal with right now about maybe this contract may not even be valid. Make sure that you're doing the legwork on it. Make sure that you're putting in the time to make sure that this seller actually has the authority to convey this property. The person signing this is the person that owns the property or has a POA that you've seen that has been reviewed, all those kind of things. And then in line 191, we have just a notice that you make sure that you provide this fully executed copy to the seller. Make sure that you show how it was delivered by email. Make sure you're keeping track records and documents of everything like that so that you're aware of how you delivered it. You can show that you have a complete agreement between you and the seller. And we kind of flew through the presentation a little quicker than I was thinking. Go back and answer any questions about CCP section 6 and 7. We can go through and have a big Q&A for the next little bit. Anything that I can kind of clear up and maybe harp in on a more clear level for anyone.
Yeah, we have one agent, Paula. I don't know, you raised your hand. If you want to talk, I clicked the button to allow you to talk, so you can unmute yourself and speak if you'd like. Or I will unmute you now. Let's see if it works. I'm trying to unmute you here. Anyway, I didn't know if she wanted to just speak out loud. Paula, are you on?
I'm here. Can you hear me?
Yeah, excellent. Have fun.
Okay. I don't think I raised my hand. I switched from my phone to my computer. Maybe something happened then. But since I'm on, I do have a question. When through the Mentor Edge program, we are going to be going through this as well. Like, so with Jessica or Sarah, correct?
Yeah, and we actually have a listing preparation workshop. We actually have it online, a recorded version from our last session, but we are going to do another workshop, like kind of a listing to contract class. So don't worry. I mean, most people have to come to these contract classes like over. I mean, I hear them all the time, and I feel like I always learn something new. So that's why, for those of you who were listening to Emily Konopasek yesterday, she said, read your contracts every day. Like, to do the best service for yourself, even if you're doing this for yourself and you're buying properties for yourself and your family, the best service you could do is know the contracts. You don't have to know it word for word, but just know like what it means and when it applies to your situation. So yes, we, as part of Mentor Edge program, we are going to help you. And that's where, if you get a listing signed and we don't know about it, we can't help you. So please, let us know. Most of the time you don't know the morning of that you're going to have a listing appointment in an hour and be like, help, I need help. Usually you kind of have a sense that you might get a listing, and that's the time to set an appointment. We can go through the specifics on that property, what items might apply, what things to discuss with the seller, so we definitely want to make sure to help you through this process, because yeah, it's a lot, definitely a lot.
I have one other really quick question. This may sound really silly, but because I might have missed a couple lines that you would have said. I sat in for the neighbor one and the FAR, and I'm just getting signed up for all of this stuff. what is the most common listing agreement that is being used right now? Or
Yeah,
are there-
yeah, this one, which is why we wanted to make sure that we kind of brought over what a typical transaction broker agreement is. So I know Josh did from our office did a NABOR contract review Tuesday. I think we're also going to be preparing kind of a difference of between what the NABOR versus FARBAR ones are versus the listing agreements as well. We're going to be starting to prepare a good amount of presentations for everyone to kind of show what the differences are between both, where they may meet in the middle, you know, but to Sarah's point, what she just said, the most important point in is to read through. I would take, you know, a couple minutes to actually, you know, read through the listing agreement, this brokerage agreement, kind of pinpoint with the PowerPoint what I brought up, what maybe things have changed, and be like, oh, I didn't know that this was in here actually. We have a ton of questions ever since May 1st, and frankly, a lot of folks didn't even realize that there was new provisions in there that agents and brokers had to abide by. So yeah, I mean, the PowerPoint that we listed here is pretty much going to be the most common one that you said. Like I said, with the caveat to the single agent one, you're going to want to use a different form for that. But on the transaction broker end, this is going to be your form to use.
Okay, thank you so much.
Yeah, you're welcome.
You know, for those of you who are mostly going to just work in Lee County or other parts of Florida, this is really what you're going to use. For those who are working in Collier County, the NABOR listing is mostly going to be the one you're going to use. And part of that is because some of the disclosures that you're going to fill out that the seller should fill out and sign should match the most likely contract that the buyer is going to give. And in Collier County, most buyers are going to be on a NABOR sales contract. And in Lee County, most buyers are going to be on a FARBAR sales contract. And that's where, you know, things can always be, you know, new disclosures can be done later. We do have another disclosures course coming up. So, you know, all of this is you're going to hear it and some of it won't make sense now, but as you hear more and go through the process, certain things will start clicking and falling into place. And I'll be sending you all out a copy of this, a link to listen to again at your convenience, a link to the presentation that is now on the Mentor Edge page, and a link to the redlined version of the contract. So
yeah,
we'll be inundated with stuff.
Yeah, no, the best advice that I can say is that it probably seems like a lot of information thrown at once, which I assume, but you know, taking the time to read through the PowerPoint and actually read through the agreement, seeing how these references actually cross-reference with your FARBAR contract, because you'll see, to Sarah's point, yes, I mean, this listing agreement is specifically more or less used for Lee County, not always, but it typically follows the format of what your FARBAR contract will be, right? So it has those kind of ties into it. It uses the same type of language, same type of things. So print out the agreement, print out the PowerPoint, and look at it through what the contract that you're using, so you can kind of see and be like, oh, this listing agreement, now I understand why I'm having to fill out this box, because it's in section 5 of my contract. Okay, so now I can kind of start to tie together the dots and get a better idea of how this is actually affecting the end goal, right? Because the end goal is to get this property sold and closed for your seller, right? So think about the way, go into it with the best aspect that you can, you know, coordinate with your seller to figure out, making sure everyone's on the same page from day one and doing that. But like I said, we're going to start doing a lot of kind of similarities and differences from the FARBAR and NABOR for people who exclusively work more in Lee County versus people who exclusively work a little bit more in Collier County, so they can see the difference. To Sarah's point earlier, the biggest tip I can give everyone is this, you know, read through the contracts, right? I mean, this listing agreement, I think the PowerPoint was maybe 35 pages, but the listing agreement is only 3 pages long. Okay, so I mean, it's not a huge form to deal with. I think your FARBAR form is 10 or 11 pages or whatnot, but take the time to read through it, because if your seller has questions, you're going to want to make sure that you're able to appropriately give them the answer that is correct.
Great. Yeah, we have a couple more questions online, and I think Paul had a question.
Perfect.
On 80 through 83, if the seller checks that box, does that have an effect on the MLS?
Yeah.
So you
so-
said 82 to 83, Paul?
Yeah,
Yeah,
so
I
if
mean-
if they check that they do not want to be on those when you do the MLS input, there's a few options that you would have to check no for instead of yes. And then it's
On the
not gonna,
MLS?
and then it won't syndicate to those websites. But also, if they do that, then they're also limiting their online presence. So for most sellers, I mean, if they want to sell their property, having the most online presence is probably best, although there are occasions where someone just absolutely does not want to be on a website that has blogs or automated valuations, but almost all of them have that now, so.
Yeah, the majority of the time, I would think that a seller would not want to, check these boxes off, especially if they want to get the most, presence from it. Like I said, this kind of follows lines 59 through 65 that the seller, at least these ones, they have to affirmatively check them off, right? It's not going to be kind of like 6A, that is the default provision here. 6B is a seller has to, affirmatively check those off. So there's a great question earlier of why would a seller actually, not want to get the most presence on? And like I said, it's very few and far between, but, NAR, found it appropriate enough to at least give the seller the obligation or the option to check this off, to, maintain exclusivity for that if they don't want the, for sale sign out in their front yard, or, if there's the seller's acknowledging and understanding that the broker is going to be limited in their options to essentially, offer this property for sale.
Yeah, and I think back when internet was kind of first starting, some people were a little skeptical and didn't want to be on it because they weren't sure, oh, random people are going to see my house is for sale, maybe it's vacant, safety issues, or, somebody might just say, I don't want my neighbors to know I'm selling for whatever reason, so they might opt out. But again, for most people, probably the most internet exposure is the best.
Yeah, which is why the listing agreement is drafted the way it is, right? Because it wouldn't make any sense to have 6B the default, right? Because that's just frankly like maybe 1% of people. I don't know what the actual percentage is, but the majority of people are going to want the most presence to get their property sold.
Great, and then this is a good question online, which I always wonder too. Just kidding. When the signature line says broker or designated sales agent, why can the broker only sign? And from my understanding is that there are some brokerages that give authorization to certain agents to sign on their behalf, but in Premier Plus, with 1,400 agents, not everyone is a designated sales agent, even though you're a sales agent. And so do you have any more insight on why it says authorized sales agent or broker? Because it messes everyone up. Almost everybody who starts on the FAR listing form signs it themselves, thinking they're an authorized agent when they're not in Premier.
Right. Yeah, no, it kind of varies. Think of this as a form listing agreement, right? So not everyone has the amount of agents that Premier Plus has, right? But from the aspect of, I think it's making sure that that agent has the authority from the broker to actually enter into this listing agreement, that there's no additional terms that's being signed on here that the broker hasn't actually approved. If you're a designated, authorized associate or agent there, that's different. I believe you have to get something in writing authorizing you to actually sign on behalf of the broker. But, you want to make sure that if you don't have that you're making sure that the appropriate party does sign off.
And just a reminder, once you're under contract, the seller wants to reduce the price. The seller wants to withdraw it. The seller wants to make any changes, extend the listing, that all needs seller and broker signature before it makes changes in the MLS. If you do make the change in the MLS, we call her the MLS police in our membership department. She will give you a notice. It's, don't worry, you're not going to get fined yet, But if it was a repetitive thing, there could be fines for not complying with, making the changes appropriate in the appropriate order. So we'll help with that. So don't worry too much. We all know it's new and part of the learning process, any mistakes you might be making here, but we're going to try to help you avoid any of the mistakes and understand why things are done the way they are. Do you have another question?
Just a question then, as an associate, we shouldn't be initialing or signing.
Do you see,
Sorry, I was having.
we see most,
But it says on initialing
Yeah.
broker sealed, don't initial or sign.
well, if you do initial the bottoms of the pages, it's fine, but it's not binding until the broker does. Do you see, because I see a lot of agents, a lot of sales associates don't initial the bottom, and it's just fine as long as the broker initials the bottom of every page.
Yeah, exactly. I mean, the big thing is on the final page. We want to make sure everyone's signature is on the page, recouping everything. If there's anything that was stricken out or added in, we obviously want to make sure is initialed by everyone to make sure that everyone's agreeing to that. But no, yeah, if the initial is missed on the bottom, we just want to make sure that everything is signed appropriately on the final page here.
Yeah, just line 154 for arbitration. If the seller is initialing there, which is recommended by Premier Plus, then you would want to initial and broker initial. But again, if it is the broker's initials, that's the most important.
Yeah. And I apologize, I couldn't hear the full question, but I mean, you'll see how seller and broker are bolded and sales associate is not bolded, right? I mean, the seller and the broker ones are the two initials that would need to be there.
Just let me get a little more clarification. So if I strike a line and the seller initials, I should initial that.
We would have to have broker, but you really shouldn't be striking out terms in a contract. If something in this attorney drafted contract is not something the seller wants, it's best to have an attorney draft something in the additional terms that overrides the contract appropriately. If it's something that needs to be discussed with the broker, something the seller does not want, sometimes the broker can give terms in here because it's an agreement between the broker, but you really shouldn't be striking out just lines in the contract.
Yeah. Was it Paul? Was that the?
Yeah.
So I mean, essentially, before we start adding in or striking out, if we add an additional term, we can say, notwithstanding such, lines 168 through 170 here supersede, whatever lines that we're trying to strike out, just to clarify if there may be another term or something that isn't exactly applicable to the transaction. Like I said, these are form listing agreements, right? Form contracts that we're using. So before we write anything in here, just make sure you're getting approval from the broker and any advice from us as well. Why is that specific provision actually being stricken? Is there a reason? Does the seller just not like it? What's the actual reasoning behind why that's there?
Another question, if it so happens that you have a listing agreement and the sellers do pass away and it's still binding, but it's going to have to go into probate, what would be the best course of action? To withdraw it or just inform people that this is happened?
Yeah, that's a great question because, I'm dealing with another issue right now and I actually, it's the same issue that I talked about earlier, that, our office has a full trust and estates department too. So we work very closely with all these issues that come up. If property, if we get the title back and probate is actually needed to clear title, it can typically take a little bit of time to get it done. So there's a couple options you can do. There's one is after you realize that probate's actually needed is to, contact our office to get probate started on behalf of your seller, because there's going to be two options, right? The first is that this is handled, you terminate the listing and get this handled so that the seller can hit the ground running. The second option is you risk getting under contract and having probate take longer then needed before the closing date, and then you can't convey clear title to the buyer, you're stuck at, maybe extending the closing date. The extended cure period under your FAR contract is 120 days. Not a lot of buyers will want to do that, right? So, it can take some time to do that. If you are in the position where, someone unfortunately passes away while you're under the listing agreement to try to get it, it may be best to just withdraw it at that stage, other than, especially since it would be also new, would have to compile all the trust documents. Did that person have a trust? Did he die testate or intestate, meaning that he had a will? There's a whole lot of ramifications that could come up with that. I think the big point of making sure that we have the appropriate, seller on here is to, make sure that, that person has the authority to convey the property, that they actually own the property. You're not getting someone, because we unfortunately have seen it where, folks, tell an agent that they're the owner of the property and nothing's really ever looked up, and we get a contract when we get title back and John Doe is not the owner of this property and doesn't have the authority to convey it. So you don't want to find yourself in that situation and have to explain to everyone why we're not going to be able to close this property because of that.
Excellent. The online folks are quiet. Anybody, we can have you unmuted online too, and you can share your questions live or type it in the chat. Otherwise, as we go through the process, unless you get a live one and all this becomes more real, that's what we're here for with Mentor Edge as well, to help go through. And as we go through, you'd be like, oh yeah, I remember Sam saying that in class, and it'll all start coming together.
Yeah, and if like I said, sometimes there's questions that are like don't really trigger right now. I know it's information downloaded a lot thrown at you in an hour and 20 minutes or so from that, and a couple of days may go by and say, oh, I actually do have a question on that provision, or how does that actually work in comparison to the contract that I'm working at. My contact information is all here on the very first page. Please feel free to reach out via phone or email, and we'll get back to you ASAP and get everyone up to speed on how these kind of work. But my biggest advice, if no one has any more questions, is just take the time to review the agreements that you're working with, right? Make sure you not say that you have to read them verbatim, but just know how they interchange with your contracts. See what exactly your obligations are, what the seller's obligations are. Make sure everyone's on the same page, because this is going to be the agreement that's going to dictate your entire listing with that property.
Great. And again, everybody will get a copy of this PowerPoint, and it is on the Mentor Edge page. So if you do need his contact information, otherwise as a preferred or as an unaffiliated business partner, WWM&R's contact information is on the internet or on Google.
Yep.
Everything's on Google,
You
pretty
can
much.
find it pretty easily via Google nowadays.
Yeah. Well, great. They got off easy and they're getting out early today.
Short and sweet today, I guess, an hour and 20 minutes. So I'll let you guys.
We'll save up the time for the sales contract, which is a little bit
Exactly.
longer.
Yeah, the listing agreement, like I said, I take a look at the listing agreement, but your listing agreement, I think it's 3 pages or 4 pages with the signature page. There's a lot of information in that 3 pages though, but the big things, make sure, run through this agreement, make sure you print it out in color, because I tried to highlight what those provisions have changed and try to call out specific things to everyone's attention, and make sure you run through that.
Excellent. Well, thank you, Sam, for your time. Thanks for everyone online and in class here.
Thank you.
Yeah, no, I hope to meet I much prefer teaching in person, but hopefully we can do that soon.